Hi, my name is Troy Spiker, and this is a presentation of a sports law case in referencing Favia versus Indiana University of Pennsylvania. This sports law case occurred in the athletic competitive year of 1990 to 91 at Indiana University, Pennsylvania, commonly known as IUP. This case is generalized by female intercollegiate athletes in pursuit of a preliminary injunction to trial based on Title IX violation of discrimination of gender. The plaintiffs leading the offense against the defendants are Don Favia, Wendy Schendelmere, and Kim Del Camo. The defense is represented by the president of Indiana University of Pennsylvania, Dr. Lawrence Pettit, and athletic director Frank Signetti. The plaintiffs, who are at the time current students at IUP of the field hockey and gymnastic athletic programs, have presented a case against the university for Title IX violation. Their merits to their claim are that the IUP athletic department has discriminated against female sport programs when compared to male athletic programs. Along with violations of Title IX, the defendants have also violated their 14th Amendment Equal Protection Clause. In this case, IUP came under financial budget cuts valued at $350,000 and was required to manage such measures. In IUP's attempt to conform to this budget restriction, the IUP athletic department made the decision to eliminate the men's soccer and tennis programs, as well as the female field hockey and gymnastic programs. To first understand the plaintiff's motive for preliminary injunction on Title IX violation, we need to look into the facts of this case with regards to Indiana University of Pennsylvania's numbers of general enrollment, athletic department participation, and athletic department financial supportive measures. During the 1990 to 91 academic school year, IUP's general enrollment was 10,793 students. Of that 10,793 students, 4,790 were males, or 44.39%, and 6,003, or 55.61%, were females. Of the general student population, there were 503 total athletes. The 503 competitors encompass intercollegiate, intramural, and club sports teams, which is made up of 18 club sports, 44 intramural, and 18 intercollegiate programs. Amongst the participants, 313 were males and 190 were females, making the percentage of male athletes 63 and females 37 of all three levels for athletic competition at IUP. Since this case is in reference to female participation of the intercollegiate programs of field hockey and gymnastics, the overall athletic participant number of 503, 397 were of NCAA participants from IUP. Of this 397 NCAA contestants of the IUP athletic programs, only 36.51%, or 149, were female athletes. And lastly, to look into the financial support and funding to assist the athletic programs with growth and development of participants, let's speak about the scholarship distribution that the Indiana University of Pennsylvania distributed across their athletic programs. The total value of athletic scholarships distributed to athletes of IUP during the 1990 to 1991 year totaled $314,178. Of this large amount of scholarship, the matchup of male athlete versus female scholarship distribution was alarmingly unbalanced. Male athletic programs received $246,755, or 79% of the athletic scholarship fund, versus female programs being awarded only $67,423, or 21% of the athletic scholarship fund. For understanding how the plaintiffs will be able to pursue and be granted their preliminary injunction, the courts will review 4 factors for consideration, along with reviewing a 3-pronged policy of the Office of Civil Rights, also known as the OCR, to declare an institution has been in violation of Title IX. The factors of consideration are to determine 1. If the plaintiffs can prevail on their merits to their claims. 2. To what extent is the plaintiff to experience irreparable harm? 3. To what extent is the defendant to experience irreparable harm? And 4. What interest does the public have in the favor of this case? The OCR 3-prong interrogation is 1. Does the institution provide proportionately equal opportunities based upon respected enrollment? 2. Does the institution have a record of growth and development and expansion of their programs based upon the trends and interests and abilities? And 3. If no opportunities for growth or expansion are available to the institution, has the institution fully and effectively accommodated current programs? To interpret these stipulations and procedures that the plaintiffs must be able to prove and the courts need to investigate, here's how the facts to the case have how argued in favor of the plaintiffs with regards to the plaintiff's ability to prevail on merits to their claims. The analysis of comparison for male versus female athletic programs, IUP, is in noncompliance with Title IX on the basis of scholarship distribution disparity and lack of female athlete participation in the perspective to general enrollment. To determine the value of irreparable harm the plaintiffs may experience, college athletics and participants on an athletic team provides many personal, social, physical, and mental advantages to being a teammate of a program. As for the defendant, the extent to irreparable harm would be minimal by Title IX. No harm would be experienced by reinstating the athletic programs of field hockey and gymnastics. It is also to note that by Title IX standards, financial budget is not a suitable reason to not maintain compliance with Title IX. And to look into the 4th factor, for courts to aid in the determination of granting preliminary injunction, the public's interest would favor any case that shows violation of a constitutional right. In the viewing of the OCR with interpretation of Title IX legislation, the institution, IUP, has not fulfilled the obligation to maintain opportunities or grow opportunities for female athletes in proportionately with general enrollment. IUP has also failed to uphold the 2nd prong by the OCR, which was to provide records for program development and expansion based upon interests and trends. The IUP Women's Soccer Club has been very competitive and has not been promoted to intercollegiate NCAA participant level, along with the decline in female athletic programs while athletic director Signetti has been in office. And lastly, IUP has unfairly distributed athletic scholarship funds to male athletic programs versus female sport programs, as proven earlier in this report. In closing, the court system granted the plaintiff's motion to a preliminary injunction on the basis of IUP's violation of Title IX. With this sports law case, implications for upcoming and current athletic administrators is to understand that regardless of financial stance on an institution, that the department is obligated to work within the parameters and guidelines of Title IX. Secondly, this case has shown the importance and difficulty level it is for a college or university to maintain Title IX compliance, with enrollment and financial balance constantly changing. Thank you,